Добрий день, пане Олексію.
Good morning, Oleksii. Good morning.
Вітаємо вас на другому етапі.
Welcome at stage 2 of the selection for HQCJ.
Конкурсна комісія проводить з вами співбесіду.
The Commission will be conducting your interview with the following members: Stephen Markman, me, Yevhen Mezentsev, and Robert Brugeisen. Two members of the Commission have announced self-recusal. These are Ted Zazhechny and Serhiy Verlanov, since Ted Zazhechny, as far as I understand, was the rapporteur on your case during the selection for High Anti-Corruption Court of Ukraine, and Serhiy Verlanov is an acquaintance of yours. He knows you personally. That is why we are having this interview in this composition of the Commission. So the rapporteurs for your interview are my colleagues Stephen Markman and me.
Я так сподіваюся, ви знаєте.
Oleksii, I hope that you already have an idea about how the interview will take place. We will be asking you questions and we are asking you to be precise in your answers. The commissioner asking you a question has the right to limit the time for the answer. If for any technical reasons your interview is interrupted, it will be resumed on a different day and at a different time.
Власне, перед початком сесії запитань.
But before we start with the questions and answers, we will give you the floor for self-presentation to tell us a little bit about your motivation for participating in this selection, to tell us about your views and ideas on the functioning of HQCJ, the judiciary, the restoration of trust in the judiciary. It's up to you to decide what you'd like to tell us during this introductory part. So, you are welcome. The floor is yours, Oleksii. Good morning, dear commissioners. Good morning, members of the audience. I'm Oleksii Omelian, judge of the Commercial Court of Zhytomyr region. I'm 44 years old. I have 2 degrees. In 2001, I graduated from the Taras Shevchenko Kyiv National University with merits. I graduated from the Faculty of Law. In 2022, I graduated from the Ukrainian Institute of Science and Technology, and I'm also involved in research activities. My experience of working in the field of law is 21 years. And my experience of working in the judiciary is 17 years. During that time, I worked as assistant judge to the Supreme Court judge, and for 5 years, I was a disciplinary inspector of HQCJ. And as a professional judge, my experience amounts to 11 years. In 2017, I completed qualification assessment. I'm also judge trainer at the National School of Judges, which means I have practical experience in developing the materials for HQCJ, and I previously participated in trainings for candidate judges. I also have the experience of assessing practical assignments. I also have my own experience of participating in different selections run by HQCJ. So this is the initial information that I'd like to present to you as part of my motivation for participating in this selection. I believe that I have the necessary knowledge and experience to work within a body that will be selecting judges. I know how different bodies within the judiciary function. I'm aware of the problems and challenges currently existing within our judiciary. And I'm also familiar with those issues that the previous HQCJ dealt with. I believe that I have this level of professional experience and efficiency where I can combine both my professional and life experience. And I'm also fit enough, which is good for me to be able to work under pressure, because I believe that the work within HQCJ is going to be stressful because of the workload. And I am inspired to enhance the efficiency of HQCJ by being its member. I want for the HQCJ to meet the level in the development of modern technologies in a way. And I think that as a member of HQCJ, I will be able to contribute to the enhancement of trust in the judiciary by ensuring the proper work of this body. Thank you.
Дякую, пане Олексію. Передаю
Thank you, Oleksii. I'm now passing the floor to my colleague, the rapporteur on your interview, Stephen Markman. Stephen, you're welcome.
Thank you very much, Judge Omelian. You know, you're the second Judge Omelian we've had this morning for our interviews. We're pleased to have both of you here. I understand you also have do I understand correctly, you voluntarily mobilized in the State Border Guard in service of the Ukrainian military? That's accurate? Okay.
Yes, that's accurate.
Okay. You are a judge on the court of Zhytomyr. That's about 140 kilometers from the capital. You have declared residence in Kyiv, but you've not declared one in Zhytomyr. Is that correct? And do you commute every day, or what is the relationship between these two cities, please? Where is your principal residence?
At the moment, I reside in the city of Kyiv. And during the period for which I filed that declaration, it was my principal place of residence. But since April of 2022, I've been in the military in the city of Kyiv. So as far as my work as a judge is concerned, within my previous declarations, I mentioned the place of residence that I had in the city of Zhytomyr. Thank you.
You did declare a residence there? I didn't see that. But you believe you did declare a residence?
I declared my place of residence in Zhytomyr in my previous declarations for the previous periods, and not for the period for which I filed my declaration as a candidate for HQCJ membership. In my previous declarations filed before 2021, I mentioned the right to use an apartment, not an apartment, but a room in Zhytomyr, a room in the dormitory.
But you're still on the court in Zhytomyr. Are you not living in that city? Are you not living there? Just a simple question. I'm not trying to...
Currently, I'm not residing in Zhytomyr, and I was not residing there last year.
How do you... Maybe I'm missing something, but how do you serve on the court if you don't reside there? Do you commute every day, or how does that work?
Since April of 2022, I'm not performing my duties as a judge. I'm in the army. I'm in the armed forces, but I'm still a judge of the commercial court.
Okay, well, that helps to clarify things for me. I did not see that. You are not currently presiding on the court. Okay, thank you. Judge Omelian, in 2021, as a member of the Association of Judges of Commercial Courts of Ukraine, you were among a list of judges who supported an effort to veto a draft law that created this commission, among other things. That's certainly your freedom to do that, and if that's your perspective, that's certainly your freedom to express that perspective. But can you explain your thinking in terms of your opposition to this commission? What was the basis for your opposition?
So, the arguments, I cannot present you these arguments for one simple reason. Because I was never against the involvement of international experts, both in the selection of judges and in the selection of HQCJ or SHCJ members. As far as this letter of the Association of Commercial Courts and other associations of courts of Ukraine are concerned, so the decision was made by the boards of those associations, and regular members of the associations never saw the draft decision, and we were not informed, so I did not participate in the voting for this decision. And it is my personal belief that the decision was a mistake, and I participated in the selection for the High Anti-Corruption Court, and this definitely proves that I support the involvement of the international community under the existing circumstances in Ukraine when we are talking about the selection of judges. And I am grateful to those experts that are involved in the process.
No, it's kind of you to say that. I wasn't focusing really on the international participation as much as your attitude toward judicial reform. Do you favor judicial reform? What kinds of judicial reform have you favored?
I definitely favor the judicial reform, and let me explain why. Because me and my family members are the beneficiaries of this reform. Just like the other members of the Ukrainian society, we want to have a judiciary that meets the demand of the society, and the demand is to have justice. And I think that we need to do a lot in order to be able to achieve that.
Well, I've heard some great judges in the American experience saying that justice is not the pursuit of the judge, it's justice under law. Do you understand what the distinction is that those jurists are making?
I can partly agree with what you are saying, and thank you for this very interesting question. I think it's a comprehensive question. Comprehensive, why? Because every member of the judiciary, every representative of the judiciary must follow the requirements of the law. But when we are talking about the behavior of the judge within the society, we are applying other norms. There are other norms that influence this behavior, moral and ethical norms that are not prescribed by law. That is why it's my belief that the system of rules and norms that regulate the activities of members of the judiciary are going beyond the law. We can say that it's law in a wider sense. Thank you.
So you understand the distinction between those concepts. That's a decent answer. In July 2018, Judge, you stopped participating in the selection commission of the High Anti-Corruption Court. I think this was done at your own request. Can you just supply some background and perspective on that decision, if you would? Please.
Yes, of course. I can tell you a little bit more about the context. I made that decision because at the time, it was a moment of truth for me. It was a time when I needed to decide for myself what I wanted to do, because I participated in two selections at the same time, two high specialized courts. The High Anti-Corruption Court, which is a criminal court, let's call it like that, and the High Court for Intellectual Property, that's a commercial court. So I was faced with this dilemma. I had to choose. I had to choose my future career, so I made the decision.
Judge, when our commission is sitting around the table after we finish interviews, talking about the candidates, including yourself, and almost all the candidates are people of great achievement and distinction and integrity and competency. But what is it most of all that you would like us to remember about your candidacy? What is the one thing that we shouldn't forget about Judge Omelian and what he can contribute to the commission? What is it that's special about you, or particularly a matter of some strength that you bring to bear in this process that you would like us not to forget as we discuss the candidates at the end of our process, please?
Thank you for the question. You're asking such interesting questions, unexpected ones, in comparison to the previous questions asked of other candidates. Well, I believe that my strength is having analytical thinking and the systemic view, which are based on my previous professional and work experience. The second thing is that I definitely want change, but not some revolutionary change, when, as we used to have in Ukraine, everything was eliminated, destroyed to the ground, and then built from scratch. I'm all for non-revolutionary changes made to ensure that we accomplish the task that is at hand. Thank you.
Well, what is the change? You say you don't want revolutionary change, and I certainly understand that, what you mean by that. But do you want transformational change? If so, what's the difference between transformational change and incremental change and revolutionary change? What is the change that we need? What would you like to see different about the Ukrainian judicial system, or about the people who populate that system, after you've been on the High Qualifications Commission for several years? How will Ukraine be different if you are able to prevail in your discussions with your colleagues on that commission?
Thank you for the question. So you were absolutely right in saying that I support evolutionary change. Evolution is about consistent development based on previous achievement, so that we borrow the best practices from the past, we add something new, and we get a positive result. The previous HQCJ has done a lot. It was able to implement an absolutely new concept for the selection of judges, and the bar that they have set is extremely high. But obviously, it's not high enough for us to be able to solve all of the existing issues. I would like to have the opportunity to discuss the change within this interview on the level both of the system and on the level of some practical issues. I mean the structure of HQCJ or introducing amendments to the regulations according to which the HQCJ operates. So all this change is rooted in the tasks of HQCJ, which will help us achieve the result. So if we are being more specific, the goal should be to enhance the transparency and openness of HQCJ, and we can accomplish this goal using different tools, but we should have a systemic view here. We need to enhance the role of PIC in its interaction with HQCJ. And I agree that overriding the decisions provided by PIC, the negative opinions, I mean, well, we need to have a higher bar for overriding this decision. We need to have 3/4 of the members of the Commission in order to override a negative opinion. And also, if we talk about the transparency in the work of the Commission, we will achieve this transparency when the decisions with regards to specific candidates and their appointment or non-appointment are motivated. Because the Commission was heavily criticized precisely for that, for lack of motivation. And I think that conceptually, the limits of special inspections, special reviews done by HQCJ should be changed. We need to apply a more innovative approach. Because the mandate of HQCJ includes the subject and scope of this special vetting, which is currently done in the form of sending requests to authorized bodies, and I see that the Commission is working with the materials received from different authorities, such as NABU, for instance. In particular, if we look at the financial information provided by NABU, I have grounds to say that it's incomplete. And as far as some conceptual issues are concerned, I believe that we have this wonderful tool, open source intelligence, which can be used in an automated way, which can make the work of HQCJ much easier, which can expand the horizons and help us get much more information about a specific candidate.
Well, Judge Omelian, let me ask my question again, because I'm not sure I've gotten the answer I was trying to pursue. You talk about things like automation, and you talk about transparency, and of course, all members of this commission, our selection commission, believe in transparency, or we wouldn't have the kind of interviews we've been having for the last several weeks, including this interview. But at the end of the process, what is the change that you would like to see in the judiciary of Ukraine? What would you like the legacy of the commission to be? What would you like to say to your family and your friends and your neighbors the High Qualifications Commission has done this for the country of Ukraine, and I'm very proud to have been a part of the High Qualification Commission achieving that. What is the new judiciary of Ukraine? What does it look like, and how does it differ from what we have today? You talk about evolutionary change, and I look at the polls, and they show 10% of Ukrainians are highly respectful of their court. Maybe they're looking for more than evolutionary change. I don't know. But what do the Ukrainian people want in your judgment? And what is the High Qualifications Commission with the leadership of Judge Omelian going to give the people of Ukraine?
Thank you for this question. So you have outlined practically the main things that should be motivating any potential member. I think that the Commission, under the current circumstances and the challenges that we are facing, including the war and the previous transformational changes in the society, I think that the Commission must ensure that the judges are selected in such a way that the work of the judiciary is efficient, fair, that it protects human rights in reality, not virtually. I also think that the judiciary must have oversight over the enforcement of court decisions. This is something that is very important for our country, because this is the other thing that affects the level of trust in the judiciary. And as you correctly mentioned, this level is extremely low, the level of trust. But the judges that will be selected by the HQCJ, the qualification assessment that has not been completed as yet, which aimed at cleansing the judiciary, but unfortunately we have not yet completed the process. I think that all these things will help us accomplish the result that we are talking about, so that we will be able to feel proud for what we have done, to feel proud for our work. Because I'm really passionate about the reform, and I think there are people that have serious drawbacks in their work. And I believe that these people have a negative influence on the formation of the image of the judiciary. They have a negative impact on the image of other judges who are being diligent. Thank you.
Do you think the greatest legacy of the new High Qualifications Commission will be its work in filling vacancies, or its work in whatever changes it introduces to the evaluation or the assessment process?
Well, thank you. It's an interesting question. I think that, first of all, we need to complete the procedures that have already been launched. This is one of the major tasks and objectives of the HQCJ, in particular to complete qualification assessment and to ensure the work of the appeal instance. And also you need to work at the judicial selection, because really we have a lot of vacancies. But this is a separate topic. I mean, the number of those vacancies that needs to be filled. But I think that another important objective of the HQCJ is to raise the bar for the work of the Commission in terms of innovativeness of its work, efficacy of its work. That must be a new stage, a new level. It would need to apply new IT technologies in this process, because the situation has objectively changed. If we recall the challenges set by COVID-19, these challenges were absolutely different than before, and it became obvious that some procedures need to be remote. Now we have new challenges, security challenges that we are facing. Again, the situation has changed objectively, and we should introduce automatic procedures that would ensure remote access to justice. And this is not only about interviews, about holding online interviews. In the previous cadences of the Qualification Commission, we could get acquainted with our own judicial dossier, and this is all about improvement of the structure of the Commission. So this work was done by different units: Professional Judges Unit and Judicial Candidate Selection Unit. And to get acquainted with your own dossier within the selection, you had to go to one unit to write a written application, to wait until this application is considered and approved by a specific official, and then you could get acquainted. Also, to get acquainted with your dossier within the qualification assessment, you also had to go to another department, another unit, and do the same. This is not effective. This just takes time, while modern level of current technology could ensure online access to your judicial dossiers.
Okay. Thank you very much for your responses, Judge Omelian, and thank you again for your participation. Let me turn you over to my colleague and fellow rapporteur, the chairman, Judge Mashenko.
Дякую. Пане Олексію,
Oleksii,
ви один з
you are
кандидатів,
among a few candidates who have got experience of working in the HQCJ, because you worked there for a little bit more than a year.
розкажіть про той свій досвід. Це було більше 10
And
років тому. але тим
could
не
you tell
менше,
about this
як ви
experience of
працювали в
yours?
комісії?
How did you work there? Well, it's a pleasure for me to hear this question, in fact. That was a really interesting experience for me, and let me remind you that back then the HQCJ was a newly established body, because before that there used to be some regional commissions that dealt with the same objectives. So this means that at that time it was already the only official state body, and that's why the concept of the activity of this body was new, and we had to develop new methodology. We rather had to apply new methodology. And the functionality of the commission was also different, because it was also performing a disciplinary function, unlike the current HQCJ. My work was related to disciplinary proceedings, to disciplining of judges, and I also had to work with other issues in the office of a member of the HQCJ. Disciplinary inspectors were kind of a patronage service. We were involved in the preparation of materials, analytical materials of the judicial dossiers, and so on and so forth. We also had to prepare draft decisions of the commission on staff issues. That was rather an interesting time and interesting experience. We were starting our work, though at that time there was no automation in place for many processes. Even the email was not there. The HQCJ didn't have official email. You may imagine what it was like. But that was a know-how of that time, and I registered our email on a specific domain, and judges could send their explanations in the e-format. So this accelerated the disciplinary proceedings. And there were, of course, other things we had to deal with. Thank you. Several times you have mentioned that
Те, що можна висловити словом інноваційність.
there must be some innovations. There must be new IT technologies, like our synth IT technologies used.
Перше питання. В умовах
So here is my first question in this respect. When there is radical underfunding of the judiciary, because I think, unfortunately, this underfunding will also be related to the HQCJ. It will be affected by this underfunding. So, Under such conditions, how are we going to introduce those recent technologies? There is no money for that. Well, that's true. It's a very relevant remark, but I think that automation will allow to reduce the costs in the future. That's why the need for automation is an investment in itself. At the initial stage, we could get this investment in the form of interaction within the international technical assistance formats, or we could suggest that some innovative companies, well, at first as an experiment, to give their products for testing and other things like that. There are a lot of options, I would say. We just need to pass joint decisions and to try and test those formats of innovative products. Thank you. Recently, the MPs have announced that the task force is established within the Committee on Legal Policy, and this task force is going to deal with the selection procedures of justice, scrutinize them. The MPs want to improve, to simplify the selection procedure, and so on and so forth. Please tell me, as you think, there is no HQCJ as for now, and it's not quite understandable whether prospective members of the HQCJ will be able to join in this professional discussion or no. What should this process be like? Just imagine the scenario under which the Verkhovna Rada of Ukraine develops some draft law, it is voted on, it is approved, but the new composition of the High Qualifications Commission of Judges will have a little bit different vision of these procedures. So what it should all be like then? Should there be some communication in place, or probably no? If you think it should be there, so what kind of communication should it be like? Any of your ideas on that matter? Thank you. I know this information about the establishment of the task force, and I think that it is a very relevant initiative, timely initiative. I'm not sure that, as you say, development of those changes and adoption of the draft law in the Verkhovna Rada will take place sooner than the High Qualification Commission will start functioning, because that is an objectively long and tedious procedure. And I'm sure that the Qualification Commission, the Selection Commission and the High Council of Justice will perform their job much sooner than this happens. This is the first thing. And secondly, since we see that the process of selection changes by the Profile Committee of the Verkhovna Rada is rather slow, and they are trying to engage different stakeholders, in particular the public, into this discussion. And since I see this, I have a lot of hopes in this respect, because they are really open for cooperation, and everybody who has his or her own vision can join in the process of the reform. I will not tell you any secret if I announce that the conceptual work of this Profile Committee of the Verkhovna Rada has changed. I think that this is most probably related to some changes in personalities in the MPs who have come to be the heads of this committee and who have some judicial background. And you're absolutely right, there is a need for this communication. The only thing I disagree is that we need to simplify. The international experience shows us perfectly well that the lengths of judicial training in the European countries is much longer, much higher than in Ukraine. So we should not simplify, we should improve efficacy and not reduce the timeline. Thank you. Our colleague Sergei Verlanov has announced self-recusal, as I informed at the beginning of the interview. But instead of him, let me ask you the question he quite often asks our candidates. How do we check integrity of judges? How do we assess integrity of judges? Yeah, that's a matter of philosophy, I would say.
На практиці, да?
Right, you are, but you will have to deal with it in practice. So what do you think the right process should be for that assessment in the HQCJ? Well, we should follow the methodology the Qualification Commission now has. The assessment takes place via some instrumental verification methods, which are tests, and during the interviews. As a lawyer, I can start answering this question with saying what is indicated directly in the law on the judiciary and status of judges. To put it simply, there is some chaos in terms of terminology used in that law. What I mean is that when we speak about integrity, assessment of integrity of members of the HQCJ, there are several criteria for that integrity, like compliance with the ethical norms is included into this integrity vetting. As far as qualification assessment of judges is concerned, that is about professional ethics, right, which is a part of ethical norms. And it goes as a separate block there. But I think that we should have clear definition and clear determination of the hierarchy of those notions and these notions as such. Otherwise, they result in violations. So I would say that it's about drawbacks in methodology. We should have clear basic definitions of categories and then how we study these categories. I think that things the methodology contains need to be further elaborated. And here I speak not just about integrity criteria and definitions. I speak about some other things. Thank you. Thank you. Let me give the floor to Robert Broekhuizen. Robert, you're welcome.
Thank you, Ivan. I think I've read it before. If I read to you from a report from 2021 from USAID, that the trust in judiciary, and Stephen Markman already referred to it, over the last years went down. And you are someone who says, I don't want to have a revolutionary change, I want to have an evolutionary change. And what I find so special about this is that Ukraine, as I see it, has only one choice, and that is to become part of the EU. Well, if you see that in the last years the trust in judiciary went down instead of up, and that the European Union has clearly stated that judiciary in Ukraine must be in order, which means up to European standards, how do you think that your evolutionary change will lead to the access of Ukraine to the EU? And is it not so, maybe your view on that, that the fact that it is so necessary for Ukraine to become part of the EU, it is the interest of the country who should be primary instead of the interest of the judiciary, who is conservative and is looking only for evolutionary change?
Thank you for this highly relevant question. Let me try to start with the reverse. I'm deeply convinced that two major objectives of the Ukrainian society and the Ukrainian state are to win over the enemy in this war and European integration. And revival or restoration of trust is a precondition for European integration of Ukraine. As far as my views on evolutionary changes are concerned, let me note and stress that evolutionary changes are necessary, but these should be highly intense evolutionary changes. And with this, they would be different from just usual evolutionary changes. Let me give an example. through some revolutionary proposals, some society members want to give the Public Integrity Council the right to settle staff prospects, professional prospects of specific judges, which means their involvement, direct involvement in determining the fate of a specific judge. It's a revolutionary choice, a revolutionary change, but does it correspond to the European reforms and standards? Of course, no, because the state body should settle such issues, and this should be the state body, which includes no less than 50% of judges or retired judges. So by this example, I'm trying to explain that I'm against such revolutionary changes, because you cannot achieve European integration objectives if you ignore all the other European standards. This is what my standpoint is about. Thank you.
Okay, thank you. If we talk about change, the system in Ukraine is that judges make declarations, and that on basis of those declarations, among others, it is decided whether the people are honest and truthful and have not acquired the assets by way of corruption or otherwise in an illegal manner. In the file there is information about you, and I would expect that you have seen the information about you in the file. Yes? Have you also seen the civil society information that's in your file?
I'm not sure that I saw information from civil society. What is the object of this piece of information, which you mean?
Well, I have in front of me a civil society piece, and it says that you have not been declaring all your properties in the past. For instance, your vehicles. It says that the candidate failed to declare the right to use 3 vehicles in the property declarations. Are you aware of this?
Well, to tell the truth, I'm rather surprised
I hope I'm not making a mistake.
with the fact that there are such documents, and I'm also surprised about with the information about 3 cars. It's somehow strange for me, because over a long period of time I've been using 1 car only, and I possess this car and it has been declared. I don't have any other cars, and I have not been using any other cars.
It talks about the car from 2010 to 2015, which is driven by your former wife, a Maxima QC, and that someone issued a power of attorney for a Ford Crown Victoria passenger car, and it talks about the car of your father, and it says that those 3 cars should be in the property declarations.
Well, now I've got your question, so now I understand what you're talking about. So as far as those powers of attorney are concerned, the existence of those power of attorneys by itself shows the use of the cars. And let me start with the car of my father. Probably it's related to Moskvich 412. Which actually doesn't exist now. But if it did, it would be 30 years old now. Really, the father issued a power of attorney, but it was never used. It was not even transferred to me, in fact. As far as Ford is concerned, the situation is rather similar. According to the law, not a single person could be driving a car if he or she didn't have the power of attorney. It used to be the law. At some point of time, I got this power of attorney, but I took this car only on several occasions. That's also quite an old car. And the requirements of the anti-corruption law said that I had to declare such property in case I use it for more than half a year, or as of the recent day of the reporting period, if I was still using it. But that was not the case. So since I didn't have those cards in physical access over such a long period of time, I did not have to declare them. Thank you.
Okay, so what you say is that there was no need for you to declare. There's all kind of other information. I no doubt my colleagues will discuss this with you, possibly. I'm not sure. But the point is that if you want to make change in the judiciary, that, of course, we need to be sure that the people who are elected in the position of the HQCJ start electing people who have no issues. And how are you going to make sure that if you are in the HQCJ and you are elected, how are you going to select people without issues? Because I see many issues time after time doing those interviews. And I'm a foreigner, so I don't know the background of all those issues. Some of them I cannot really understand. But I see that there are issues. And I discussed them, we discuss them with candidates like you. And when I think about it, that also the discussion about those issues is not good for the view of the people about the judiciary, is it? So how are you going to change this? And how are you going to select people who have no issues?
Thank you. I've come to like your question, you know. I think that the work of the selection commission is, in a way, a new standard in settling the issues of integrity. You're absolutely right in saying that these issues need to be studied, and the only thing I don't quite like is that normally these issues should be studied before the interviews, and probably the information should come before the interviews for clarification purposes. The mechanism of study of integrity or assessment of integrity could be different. I agree with the mechanisms that currently exist among the tools used by the Qualification Commission. And I think that we should not limit ourselves to those mechanisms. We should develop new tools for checking integrity, for no one to get any single doubt that all issues related to integrity have been studied in an extensive and comprehensive way. And let me give a specific example. Let's take close relatives. You always request, I mean, you mean the Commission, the HQCJ always files requests, but for some reason, I can see that requests only in relation to close relatives are given, but I think that it should be wide. I mean, the requests concerning integrity of the judge's wife's sister or her husband should also be there. So it should be wider. As far as the tools are concerned for assessing integrity, I think that we should study not only the current status, whether the person corresponds to integrity criteria, but we should also study the resilience or the resistance of the person for the future, how the person can really resist some challenges. Because when we provide recommendations to judicial candidates, we may sometimes see that the candidate absolutely meets all the requirements for now, But when this person gets into the environment of new opportunities, wider opportunities, let's call them that way, will he really be resistant to all the challenges and temptations? I think that this issue should also be studied. Thank you.
Yeah. Well, when I listen to you, I do not hear immediately, let's say, solutions. But let me formulate it differently. Let's say that you're elected in the HQCJ. And of course, the first simple question is, let's say that you know something about, there's a judge that has to be evaluated. And you know something bad about this judge, which does not come forward out of the figures and the information in front of you. What would you do?
Well, whenever I get some new information, if this is the request directly, the information coming directly to me and it is within my competence, I will take pains to systemically study the circumstances of the case. And I will check whether it is really true information and what are the reasons for this information. And I will I will give a chance to this judge to provide explanations, because that's what the standard tells us to do. Besides that, I think that this information should anyway be considered by the Commission as such. Well, there are some limitations. Suppose if this is information about some very private or even intimate elements of private life, we could have different formats of study or discussion of this information. It may be public or it may be closed discussion, so to say. But anyway, this information should be scrutinized. There must be some study, there must be response, a systemic and effective study of this information and the reasons.
Okay,
Thank you.
Please, Yevgen, the floor is to you.
Thank you, Robert. Доброго дня. Пане Олексію,
Good afternoon, Oleksii. Let me continue communication with you. I'm Ivan Mezentsev. And to close the round of questions related to declarations, let me ask the following. You know, while studying your files, the Commission has come across some unconventional, untypical situations that should be discussed in public. One of them is the fact that you divorced your wife, Maria, if I'm not mistaken. Please correct me if I'm wrong with the name. So you divorced her in 2012. Along with that, you got children after that, and you indicate them in the declaration, and you indicate her in your declaration as the person with whom you live together. So it's kind of an unconventional status. What are the reasons for that? Thank you for the question. That's really an unconventional situation, but this situation also stresses that judges are just humans. Well, it's obvious in a way. Why am I not married to my wife? Because that may evoke some misunderstanding. My wife, because of some circumstances of her communication with the judiciary, does not want to register official marriage, because she does not understand while getting married, she has to explain to the state the reasons for her decision, but while divorcing someone, you have to explain the reasons why you want to divorce a person. So this is one thing. On the other hand, according to the legislation, I have to declare this relationship and the property status of my wife if our relationships look like family relationships. So in 2012, I really divorced her, and the reasons for the divorce were as follows. In 2011, on the 13th of February, a baby was born in our family, and unfortunately so happened that their delivery was rather difficult, and the psychological condition of my wife, as I was explained later by psychologists, was very special. And the next day after the baby was born, I went to go to the High Qualification Commission with high load, and objectively I could not be providing any help to my assistants, my wife, and to my child. Moreover, in 2012, I participated in the competition for the filling the vacancy in the commercial court, and it took a lot of time. I did it without the consent of my wife. I just applied for the position in some other territory, in some other region. Of course, she disliked that. I understood that she wanted me to stay together with my family, but I also had some reasons and some motives, probably career motives behind that. So the integrity of those circumstances led to the divorce. Okay, so your career actually interfered into your family life. Well, not exactly. That was, along with that, psychological support my wife needed, and psychological perception of me, notice of her husband after the hard delivery, so a lot of issues. Okay, that's enough for us to understand what the situation was like. There is no need for further explanations in this respect. Well, in fact, you have answered Robert's question about Moskvich, produced in 1974. Everything is clear in this respect. You understand why you were using this power of attorney in a way, because it's really true that by a certain period of time you could not just be driving if you had a technical passport. It was considered that you were driving a car illegally if you didn't have a power of attorney according to the law until a certain period of time. But in your paper declaration of 2013, you identified Toyota Corolla produced in 2014. So here is a chronological miscorrelation. Is it a mistake, or what is it, or misprint, or what? From the point of view of formal regulation, that is really miscorrespondence. But from the point of view of common sense, we can see the correspondence in terms of the transparency and openness conditions for my property status. Everything is clear. Let me explain. In this declaration, I didn't have the grounds to indicate this car, but again, that was according to the requirements of the then anti-corruption legislation. But I acquired quite an expensive car. All colleagues started asking me, have you declared your car? Moreover, now we still have the mechanism of controlling similar expenses when your status, property status changes. And according to the law, now when you submit your declaration for the current reporting period, you have to make a report on the change in the property status. So even before this mechanism was introduced by the law, I had already decided to set some limits for myself, and I decided that they have to indicate this thing and never to hide it. So you were so happy about this Toyota that you indicated it in 2013 instead of 2014. Okay. Of course, this is just a misprint, but this is not hiding your property. This is showing your property too much, I would say. You were a disciplinary expert of the HQCJ in some period of time, and you know from your own experience what the structure of functioning of the state body is, at least what it looked like back then. What would you take out of that system of functioning in terms of the organization of the structure? I don't know, the number of units, the number of departments, some organizational elements, what would you exclude? What you would consider to be wrong, and which one would you add to the work of the HQCJ? I'm talking only about organizational entities.
Thank you for the question. It's really very practical. And I think these things must be discussed. As far as the structure is concerned, we need to change. We need to change the structure in order to implement our tasks. As far as inspectors are concerned, let's start with them. It is my belief that the norms that we are currently having in the legislation, the requirement for having the inspectors, I think that inspectors should be subordinate to the supervisor who is a member of the commission, not directly. But inspectors as such, they are a patronage service. They are the eyes and the hands of a specific member of the commission, and these eyes and hands must ensure in the direct connection with the HQCJ member that this function is implemented. As far as the functions of departments or divisions are concerned, I see that the situation is being improved. On the basis of the materials that were provided to me for analysis, I now see that the judicial dossier consists of specific sections like previous qualification assessment, participation in previous elections. And I would also add a section like that for candidate judges, so that within any process or procedure, be it selection or qualification assessment or other types of assessment, we could have all of information stored in one place in order to analyze it. As far as this structure is the so-called Office of Reforms, I would like to see it within the HQCJ. This is something similar to what we are having in the executive bodies. I think that this office should ensure feedback with the stakeholders, with those implementing advanced technologies, researchers, so that we can adjust some things in the work of HQCJ so that they could introduce some changes. Maybe we don't need to have the chair of the commission and deputy chair of the commission as part of that structure.
Зрозуміло, пане Олексію.
Thank you, Oleksii, for your answer. I think that's enough.
Цим питанням. Хотів би у вас поцікавитися наступним.
I have another question for you.
Якщо ви станете членом
Of course, should you be appointed as an HQCJ member, you will have lots of work lying ahead of you in the upcoming years, and I hope you realize that.
окрім того, що треба буде провести величезну роботу.
In addition to doing a lot of work in selecting judges, completing the qualification assessment, the HQCJ will be facing the issues of appealing their action, because you will be contacting a large amount of judges and lawyers. As a judge of administrative court, I'm asking you, a judge of the commercial court. So, do you think maybe we should introduce the possibility to appeal the decisions not just to the Supreme Court? Maybe there should be some kind of administrative procedure for the appeals. Perhaps we should install some appellate chamber or supervisory board that could review some of the decisions, or at least work out the procedure for administrative appeal of the decisions of HQCJ and inaction of HQCJ. Thank you. I think it's feasible that we discuss this question as well. And it does make sense in view of the following. If we look at the analogies, for instance, at how the HCJ works, when there is a disciplinary issue, it can be reviewed by the disciplinary composition of the council. And I think that this administrative procedure for appeals does exist in the HQCJ. That's review of the opinions of PIC. So in a way, it's administrative appeal. Yes, but that's something that has to do with PIC, not with the activities of HQCJ itself. I think it is feasible, before we transfer these decisions to courts, to introduce this ability of appeal, to review the decisions in analogy to the structure of the judiciary itself, because we have trial courts, we have appellate courts, then we have courts of cassation. So the reviews don't leave the judiciary system. Thank you, Oleksii. Let me ask you another question. So since you're already drawing analogies with the judiciary, perhaps it would make sense to go back to the previous model of the functioning of HQCJ, which we had in 2010, 2011, when we had district qualification commissions in every region, and they were subordinate to HQCJ as the appellate body for those district qualification commissions. In your opinion, would it be able to decrease that huge workload that the HQCJ will have, because we did not have the HQCJ for the past 3 years? That's an interesting suggestion, but I think that at the current stage, we should not be implementing it. When we are ensuring efficient, transparent, and accessible system of justice, that is not something that we should be doing. Yes, we used to have these district qualification commissions, but unfortunately, they failed to ensure the required results. There were many reasons for that, including some systemic reasons, but the major reason was high risk of having some kind of nepotism in those regions and some corruption risks, which were quite significant. And that is why the creation of a single disciplinary qualification body, that was the recommendation of the European partners. I think that maybe in the future we could go back to this discussion, but not at the current stage, unfortunately. Yes, thank you, Oleksii. I understood your answer. Unfortunately, we are pressed for time. I have one more question for you, and then I will pass the floor to Stephen. With regards to professional competence, we often ask our candidates about their attitudes towards advanced training for judges. And professional competence is one of the cornerstones defining our candidates as eligible. And of course, the National School of Judges plays one of the key roles here. The National School of Judges is the key player in advanced training and training of judges and candidate judges. So in your opinion, the quality of training and the curriculum of the National School of Judges, should they be reviewed and analyzed, or should the HQCJ have this function of quality control over the National School of Judges? You are asking really serious questions. Let me start by saying that for each particular judge, completion of training at the National School of Judges is not sufficient enough. And let me explain why. If we look at soft skills, for instance, the National School of Judges does have a number of courses pertaining to soft skills, but it's obvious that it's much easier to get those skills outside of the training at the National School of Judges. As far as advanced training for judges is concerned, I think there is an objective need for that. And it's motivated by the fact that some 20 years ago, the person could have had relevant knowledge. And now the situation may be different. So you need to update your knowledge these days every 5 to 7 years, but I think in the future this process will be even shorter. The period will be even shorter. As far as the curriculum is concerned, let me exemplify this on the curriculum for candidate judges. The curriculum itself is not bad. But what I'm concerned about is that some parts of the curriculum are directed towards studying of the opinions of the Supreme Court or judges of the judgments of the Supreme Court. It's orientation towards replication of a specific norm from the laws and not on its interpretation. It's just memorization. As far as control over the activities of the National School of Judges is concerned, I think that the problem is that the relations between HQCJ and the National School of Judges are not regulated enough. And if we look about the security of tests, the security of conducting practical assignments, we have this problem of ensuring the security. I understand that there is a testing center working there, but the algorithms of transferring information and protecting it, and even the algorithms for assessing practical assignment are not secure enough, are not worked out enough. Thank you, Oleksii. Thank you. Thank you for your answer. I'm now passing the floor to Stephen.
Judge Omelian, can you explain to me how does a judge of Ukraine end up being a defendant on 2 occasions in a non-payment of utility case?
Yes, a judge can be a defendant in cases like that. A judge is a person like any other person. They are supposed to pay utility bills.
Скоріше питання стосується обставини.
It's more about the circumstances on how a judge could have been a defendant. It's not about whether it's possible for a judge to be a defendant in cases like that. Yes, I was a defendant in one civil case about debts on utility bill payments. But the circumstances were quite curious, I would say. So first, there was this application on charge of the debt, and then there was a lawsuit. So let me start by saying that the very fact of having this debt was something that I didn't know about until I received a court summons to appear as a defendant. I will not take too much of your time. trying to explain this, but let me finish by saying that as a result, the petitioner withdrew their lawsuit, so the proceedings were terminated on their initiative. Obviously, on the grounds that proved that their legal position was not strong enough.
Judge Omelian, we had a brief discussion earlier on concerning your non-declaration of property in the Zhytomyr region, and you indicated that that was only after you had left the court. There's information I have that suggests that also for the years 2012, 2013, 2014, 2021, you did not indicate any real estate belonging to you in the Zhytomyr region, even though you were on the court at that time. Is that accurate?
Yes, with regards to the year 2012, I indeed did not declare any real estate in Zhytomyr region. In 2013, as far as I remember, I also did not declare any real estate. In 2021, I did not declare any property. 2012, 2013, I was working in that court in Zhytomyr region, and from time to time I stayed at hotels, but my principal place of residence was in Kyiv. I was trying to combine my work and taking care of my children, but I realized that it was hard to use public transport and it affected the efficiency of my work. So in 2021, the situation was similar, and in the middle of the year, I took a vacation, and there was no need for me to have any accommodation in Zhytomyr. I turned down that room that I had in the dormitory where I stayed between 2015 and 2020. That's why I did not declare anything.
You know, I don't understand some of the rules as well as my Ukrainian colleagues do, but aren't there expectations on the part of people that their judges, their local officials, their local representatives will be living within the same community they are and not sometimes coming in and staying at a hotel overnight, but that they'll be actually living and participating in that community?
So with regards to my situation, I would exemplify it on my own example. The distance between Zhytomyr and Kyiv is 130 kilometers. Objectively speaking, the center of my life interest, the place where my family is staying, is the city of Kyiv. But this distance of 130 kilometers is a 2-hour drive by car. It's absolutely normal. It's an accessible distance, which allows me to travel back and forth. And even more so, while driving my car, I was using that time efficiently. I was listening to some audio lectures. I was pondering over some cases. So even the time for commute, I was using it with purpose. You said it yourself that it happened only in 2012 and 2013, so it tells us that I'm trying to adapt, that I'm trying to combine things. When there's lots of work, when the workload is high, and I see that I need some rest and not to spend time on driving, then I don't do that. I can rent some accommodation, and I can then declare that accommodation.
So
But-
are you saying, Judge Omelian, that you did commute on a regular basis from Kyiv to Zhytomyr?
Yes, for some time I did commute regularly from Kyiv to Zhytomyr.
But at the same time, it's fair to say you were never a member of that community as a community is understood. I know the American experience may be very much different, but I've never heard of a judge who has a jurisdiction, if it's local, state, national. I've never heard of a judge who hasn't lived within the boundaries of the jurisdiction that he presides in. Is it different in Ukraine?
The situation is a little bit different in Ukraine. For those years that I've been a professional judge, I was not living within that community for more than 3 years. But if we talk about the other 8 years, then I did declare me staying within that community and residing within that community. And I believe that the link between a judge and the community cannot be categorized by the sole fact of them having a place of residence within that community.
Okay, thank you very much, Judge. Thank you. Thank you.
Да. Пане Олексій, ми
Oleksii,
вичерпали майже весь час відведений
the time for your interview has almost run out.
прямує до свого логічного
That is why we are approaching its end.
підсумуйте і що
We are now going to give you the floor for some concluding remarks.
найважливішого, будь ласка.
What is it of importance that you'd like to share with us? Thank you. Indeed, time flies by. And when you have this high level of conversation, a conversation that is this intense, during which you discuss relevant and interesting questions, I think it's great. And I would like to thank the commissioners for this level of discussion. Let me express my gratitude to the commissioners for spending their time, because it's a valuable asset. Let me thank the people who support the commissioners. And let me say that having this kind of discussion gives the society an opportunity to understand what problems exist in the judiciary, listen to potential solutions, and in general, it will result in a professional and efficient dialogue between the judiciary and the society. Thanks a lot. Glory to Ukraine. Glory to heroes.
Дякуємо вам, пане Олексію.
Thank you, Oleksii. This is the end of your interview. Best of luck to you and take care. Goodbye. Goodbye.